This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about dog bites, and specifically an injury by the existence of a pit bull dog was unambiguously excluded because the court realized and read the entire language of the exclusion and refused to accept a partial description and interpretation of a policy wording. The case started in July of 2020 when a young boy was injured when a dog attacked him in an apartment complex owned by Missy J, LLC. In Missy J, LLC versus Westchester Surplus Lines Insurance Company, a December 19, 2022 decision of the United States District Court for the District of New Hampshire, the insurer refused to defend or indemnify Missy J because of an animal's exclusion in its policy. After the boy's mother sued Missy J to recover for his injuries, Missy J sought coverage from Westchester under its commercial general liability policy. Westchester denied coverage and refused to defend Missy J. Missy J sued in New Hampshire State Court against Westchester, seeking a ruling that the party's commercial liability policy provided coverage for the lawsuit against Missy J and the boy's injuries. Westchester, of course, removed the case to the United States District Court. The factual background was that Missy J owned an apartment complex in Manchester, New Hampshire. Westchester insured Missy J under a commercial general liability insurance policy that also lists certain injuries and damages for which it does not provide coverage. The policy included an animals exclusion provision that provided, quote, "This insurance does not apply to bodily injury, property damage, or personal and advertising injury arising out of or resulting from the ownership, existence, maintenance, presence, training, or use of animals on an insured's premises or in an insured's operations, including dogs," close quote. On July 10, 2020, the pit bull attacked a young boy who was visiting at one of the apartments in the complex. The boy's mother sued Missy J, and Westchester denied coverage on the basis of the policy's animal exclusion. Missy J sought a declaratory judgment that Westchester wrongfully denied coverage for the dog attack at the complex. In support, Missy J contended that the animal exclusion provision in the policy was ambiguous and can reasonably be interpreted to apply only to an animal Missy J or its agents controlled or used in its operations, such as a guard dog. Missy J argued that because the exclusion provision was ambiguous, the court must construe it against the insurer and in favor of coverage. Westchester disagreed and contended that the animal exclusion provision was clear and unambiguous and precluded coverage for the boy's injuries because they arose from the existence or presence of a dog on Missy J's premises, both words of which are contained in the exclusionary language. Missy J and Westchester agreed that Missy J's liability for the dog attack would have been covered under the policy but for the animal exclusion provision. That plain language encompassed the factual circumstances for which Missy J seeks coverage in this case. A visitor's bodily injury that arose out of the existence or the presence of a dog on Missy J's premises. The exclusion explicitly and unambiguously excluded bodily injury that arises out of an animal's presence on Missy J's premises, which specifically included the complex that was the subject of the insurance. That language covers the exact factual circumstances for which Missy J seeks coverage in this case. Liability it incurred because of the boy's bodily injuries that arose out of a dog's presence in the complex. The dog certainly, if it was not present, could not have bitten the boy. The animal exclusion provision is and was written in clear and unambiguous language and excluded from the policy's coverage the incident at issue in the case. Parties cannot create ambiguity from whole cloth where none exists, because provisions are not ambiguous merely because the parties interpret them differently. Therefore, the court concluded that Westchester carried its burden to show the presence of coverage under the policy and is entitled to summary judgment. Westchester's motion for summary judgment was granted, and Missy J's motion for summary judgment was excluded. In my opinion, just because Westchester and Missy J disagreed about the meaning of a clear and unambiguous exclusion does not make the term ambiguous, since the dog existed on the premises of the insured and was the cause of the child's injury. The exclusion applied. That it would also apply if the dog was placed there for Missy J as a guard dog does not eliminate the exclusion for any dog that existed on the premises, whether a pit bull or a Pekingese. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog by clicking on the subscription link at the blog. You can view these videos on YouTube and rumble.com, and you can also subscribe on YouTube and Rumble. And I'd appreciate it if you appreciate and find interesting the blog posting and the video, to click on the like button and the Rumble button showing that you do enjoy them. In addition, you should consider subscribing to my locals and my locals community and my Substack publications, where for a small extra fee you can also receive detailed claims coverage about information not necessarily contained in a simple blog posting. If you found these videos useful and interesting to you, please tell your colleagues and friends so that they can also subscribe. Thank you for your attention.